I'm looking forward to it. I know this has been in the works for a while, so tonight our presenter is talking about approaches to cybersecurity law, guide for information security professionals. David Jackson, he's been a member of the chapter for quite a long time. That's one of the benefits of becoming a member is you have an opportunity to present on a topic of your choice, as long as it relates to cybersecurity in one means or another. So David put together this presentation. We haven't had a presentation on cybersecurity and law in quite some time, so this is a fantastic topic. So I'm really looking forward to it, so let's please welcome David Jackson. Thank you.
All right, thank you. So I'm talking about cybersecurity law. I've been a member for a couple of years, and I'm an attorney by day. I do regulatory law, and I work for a government contractor. And then we talked about 6 months ago, and there were some questions that came up about law and how it applies to cybersecurity, and that was really the genesis for this presentation. So tonight I'm going to talk about three topics. How to view cybersecurity law, how to kind of have some organization about the laws, and kind of how to think about the overview. I'm going to talk about the law being, it's a wonderful tool, it's an imperfect tool, and it's not all powerful. And then I'm going to end with talking about the future of cybersecurity law. So how to view the cybersecurity law landscape. Most of what we learn about cybersecurity law is for the CISSP exam in Domain 1. And we talk a lot about things like cybercrime and intellectual property, privacy, maybe the different legal systems, but we don't really, it's not really presented in kind of an organized format, and it can be overwhelming. And so what I wanted to do was build a roadmap for you. And so what I did was I kind of took a big view of the laws and said, it's better to view it by who is impacted. And I was calling it the participants, but they're kind of unwitting participants. You know, it's individuals, there's laws targeting individuals, there's laws targeting businesses, laws targeting the government, and then there's an international component of each. So laws that impact individuals really divide the individuals into two categories. You have the general public, just us on the street, and then there's a category of criminals, people that violate the law. And so cybersecurity laws are really designed for targeting individuals and separating criminals from the general public. But I'm also going to argue that they also encourage e-commerce. So a lot of the laws that are targeting individuals in terms of separating them from criminals, talking about hacking the government computers of banks, organized crime, selling trade secrets, identity theft, even selling passwords to accounts is listed. And so that idea is, okay, so if you do this, you're violating a law, you are, it's fines and penalties, and perhaps prison. But the other side of it is, it's not explicitly stated in the law, but I think that the law often encourages e-commerce. And what it means is that, especially in the 1990s, there was a focus on, reducing costs, it's faster, it's less paper, and there was a framework for global electronic commerce that was developed by the Clinton administration in the 90s to really encourage people moving online. But so the laws, there's always sort of this balance by encouraging it, but not picking any particular winner, and certainly not filling the goose that lays the golden egg. It's really not explicit. So this is I'm suggesting that the law encourages e-commerce, but it doesn't really say. From a business standpoint, not all of businesses are affected by all cybersecurity laws. It's really targeted to certain businesses, but, specifically telecommunications, healthcare, government contractors, banks. And it's not all data. It's health information, financial information, government data, school records, video records. This is mostly in the realm of privacy. Business and government. Business and government have this bifurcated relationship. Basically, that at one level, there's a partnership. We want, the government wants businesses to share data, but also that governments regulate businesses, so there's a regulatory element to it as well. And this exists simultaneously, and the lines can get blurred. So laws that impact government, specific government agencies are affected, so law enforcement, military, and then the executive agencies. And the real focus here is to limit power and to defend U.S. interests internationally. So what does that mean? Law enforcement, a lot of the laws are on, dealing with surveillance and how do you track criminals. Military, there's laws that prevent domestic occupation. And then in government agencies, Privacy Act and the Administrative Procedures Act that provide due process and restrictions on how data is processed. And so how does international fit in? And in a global economy, you've got same groups of people, but it's primarily a U.S. government facilitated relationship. And it can be difficult to enforce across borders because you have different legal systems you have to go through to make requests. So individuals, you may have issues with extradition. Businesses, there's trade secret theft, there's export control trade, which is a lot of what I do in my daily life. And in government, the cyber wars, cyber terrorism, cyber espionage. So putting it all together, what I've done is I try to kind of give you a map, a roadmap for this. And so the laws are going to impact individuals, businesses, and governments differently, and those relationships between them are actually where cybersecurity law really lives. And so this was sort of a big kind of overview to set the stage. I'm going to stop into any questions at this point.
Well, I noticed that you didn't, by the way, you could speak just a little louder, it would be helpful.
Okay.
I can hear you, but I'm not sure that they can. You didn't talk about privacy at all, and I'm assuming you're going to get into GDPR, because that's where European law comes to impact us when you talk about international.
Yes, and that's true. It depends on a lot of those issues, and yeah, I'm going to talk about GDPR later.
Okay.
Is cyberbullying and also children being subject to crime by predators, is that part of a different law, or is it?
It's usually.
Is it cyber security law, or is it cyber law?
It's more, the law deals with trafficking of persons and what have you.
It's in there?
Specifically, and then how it's done. So there's sort of a, I don't really get into that particular level of detail, but the idea is a lot of the laws that deal with international crime are going to be criminal laws that have an electronic component. So they're usually prosecuted as an international, as a crime rather than as a cyber law. Okay. The law isn't all powerful, and it's actually pretty imperfect. So one of the things I wanted to sort of dispel is a lot of times when people ask me about how the law applies, there's this idea that the law applies everywhere, and it's actually really quite limited, and that the law can apply to any new situation. And in actuality, the law kind of looks backwards, and it looks for something that happened before that it can tie to a new situation, before, figuring out how to deal with a new situation. And the law keeps up with the changes of the times. It's actually really slow to change. It takes years to go through the lawmaking process, and we'll talk about that. How is it limited? The law is limited to certain people in certain situations. And for our purposes, what I wanted to do is use the journalism questions to, to take apart the law and analyze it a bit. And I'm going to start with something kind of, one of the first big cybersecurity laws was the Computer Fraud and Abuse Act. But I thought it was a good example to sort of break apart. Criminalizes unauthorized access to government and financial institution computers. The Department of Justice has a practice manual on CFAA, and it provides more guidance on how to handle these cases. But the actual law is pretty convoluted, so what I've done is abridge it slightly for our discussion. In simplified form, it has, whoever intentionally accesses a computer without authorization or exceeds authorized access, obtains records from a financial institution or Department of the United States, shall be punished by fine and imprisonment, and then there are different federal agencies that have jurisdiction. So how this can be analyzed with the journalism questions kind of breaks it down into, whoever. And this, in a legal sense, we talk about natural people, as in people, versus legal people, legal persons, which are corporations. So likely to be a natural person. And the what of this is the intentionally accessing a computer. And that's kind of key because it's intentional, without authorization or exceeds authorization. So what I'm trying to do is sort of get the different pieces of the law kind of into an organization. It's federal because of where it's been, where the law is listed. And it's only in certain circumstances with federal government or financial institution computers. It's prosecuted through fines in prison through those agencies. The big point of this is the why. It's not, lawyers don't look at policy discussions and policy arguments as having a lot of weight. What we tend to do is look at it from the standpoint of what's the words on the page. And that can be frustrating because when you're talking about a situation where there's really strong policy arguments, the law doesn't really speak to that. And so the policy of the CFAA, I would say, had to do a lot with sort of the theme in the 1980s where everything was moving online and there was a lot of risk of hacking into government. And I kind of said, 1980s movie War Games. So where is CFAA limited? CFAA. It applies only to certain situations. Federal government, federal financial institution computers. That whole idea of authorization. And then federal law enforcement investigates. And in a lot of cases, that turning over an investigation to a federal agency really kind of limits your participation afterwards. Where it doesn't apply, it's not your neighbor's computer. It's not filing your state tax return, and it's not mistyping the URL. Neighbor's computer may be covered under state law, and so it may still be a violation. It's just not a federal violation. State tax returns are authorized, and then not mistyping the URL is not intentional. Now, if you mistype it 50,000 times, it's starting to look more intentional. So in conclusion, it's only certain people, locations, activities, circumstances. And the why doesn't really matter. Okay. So, the law looks backwards before it looks forwards. So one of the things that I started to look at, and it's hard to explain I think, in terms of a technology context. Our legal system is based on precedent. So everything is based on what happened before. And especially in the East Coast and Virginia, the law came over from England. So that precedent came over, on the boat with some of the original settlers. So, and that forces every legal analysis to start by looking backwards. And so it's kind of a strange concept, I think, when most of us are looking forwards. So I'm returning to the 1990s and AOL and spam. So I worked at AOL in the mid-90s, and I was a spam fighter, so I worked in their Internet Abuse Department. And AOL was a major target for spam, as you know. And AOL sued spammers as part of its strategy. It was difficult because spam was such a weird thing. Like, it was email. It wasn't a physical thing. It was sort of, like it was really hard to quantify. And so what AOL did is they sued on this theory of, it's called trespass to chattels. So in law school, I was taking torts first year, and torts are basically like things you can sue in court, things that, intentional wrongs, things that people do to each other. And the idea of trespass was, in this case, it's more interference. It's not, I took something from you and you can't have it, but it's, I interfered with your enjoyment of whatever, of your possessions. And so the way I would translate this, sort of into kind of more common language is, someone interfered with the use and enjoyment of someone else's thing that caused damage that can be calculated. So this was kind of really simple. But the theory was kind of interesting applied to spam, because what it was is spammers interfered with AOL's use of its mail service to serve email to its customers, and it cost AOL time and money to process the extra mail and burdened their equipment. And so this idea of damage is suffered by reason of loss of its use is what I call interference, because it's not total, it was just bothersome. And so we read about this case in law school, and I went up to the professor, I said, by the way, I've been deposed on this when I was working at AOL back in the day. So it was kind of a huge issue, and part of why they went to trespass to chattels is it was the only thing that seemed to fit, and there were a bunch of different legal theories that they were working with. But this was part of their strategy. The challenges to this.
How did you know the source of the spam and who to sue?
So earlier on, people were less trying to hide their identities. And you would get like headers that were forged. But what we would see is connections from different email servers. And what we would see is, we could see by volume, we could see spikes. And then we also began to get, what AOL did was set up kind of the report spam function, and that allowed them to quantify the numbers of emails that were received that were not wanted, and also so that they could separate the real from the not real. Yes?
Do you have more insight on that case? For instance, did AOL collect any money from any of the spammers?
Yes.
And who did they sue?
Well, they would target the companies, they would track the underlying companies. So the big one was so the one that, we thought, they fought a lot with Cyber Promotions, Sanford Wallace, and that was the case that got a lot of attention because it was a large volume of mail. And a lot of it was, in terms of the deposition, is I was working in Internet abuse there. So I'm declaring, okay, so we've got 6 people that report to me, we were all processing these complaints of spam. How much time did it take? What was the volume of email like? That was a lot of what we were being asked about in that context. And so it really did take a lot, it took a lot of time in terms of developing this legal theory, because during that time, when I was hired, AOL had 4 million members. When I left, they had over 20 million. So when you look at that kind of growth, it's really hard to separate that growth then from a level of email interference that could be calculatable into damages. But, and it was really kind of, at the time, it was kind of an odd way of that legal theory of trespass to chattel. I can remember we were talking about property law, you know, whether an email box is virtual property. I mean, it was really tough to have a discussion about, so how do we sue with a law that is built in the real as opposed to the virtual?
So did that case make precedence now? So like, for instance, can that be translated to Gmail, which probably has a lot more than 20 million accounts, I assume? Because everybody uses Gmail and everybody's getting spam left and right every minute.
So
Do you know if they have taken that case and gone after spammers?
I don't know that they have. I do think that, I mean, is it presidential? Yes. Is it out there? The case law is there. But a lot of what happened is that the law then, you know, Congress passed CAN-SPAM in 2003. And there are 2 things that did. One is it changed that whole idea of interference and to unsolicited. So it's not a question of whether this is interfering with your mail servers anymore. It's my customers don't want this, or, you know, I as a consumer, you know, don't want this mail. And it dropped the volume analysis requirement. So it's less, I mean, it's still there as an option, but CAN-SPAM kind of made it much easier to sue spammers. Where it gets complicated now is in the spam has largely gone in a different direction, and it's been more, you know, phishing in the last few years. It's been more phishing emails. They're still very hard to track with more forged headers and all of that. But because the law passed, because when Congress passed CAN-SPAM, it really did change a lot of the dynamics. So to your question, can they still do it? Yes, it's there. It's there as precedent, and there's a bunch of case law that supports it. But it's really difficult to build that case. It's very expensive, and you've got to have the analysis of your mail servers and volume to discuss it.
Thank you.
If you were dumped several decades back in time,
Yes.
would you make the same case? Was that like the only option you really had, trespass and chattels? Or looking with your hindsight now, would you wish you would go a different way, like
They actually, what ended up happening is that, in fact, the case I cited had sort of 5 different legal theories that they were pursuing. Things like, under the Lanham Act, degradation of trademark. And so there was a lot of different theories. And the reason I pointed this out is it's kind of an odd theory because it's based on physical, you interfered with my stuff in a physical way. And so it's translating the physical and the virtual. Would I have approached it a different way now? Possibly. It's just, again, transporting back, you were dealing with judges who didn't understand anything about what the internet was. And, you know, in the 90s, I remember news reports of, what's this thing called email? You know, that kind of thing. And so there was really trying, you know, internet service was on the cutting edge at that time, and trying to explain to somebody who thinks of a folder as a paper folder, you know, I remember cases where they would print out the emails to show the volume, just to do that kind of a demonstration. And so that's the mindset that had to be shifted. So going back, I don't know if I would do it differently because this worked. It was hard. And then whether or not CAN-SPAM was the right result, it was the best compromise because the Direct Marketing Association, which does email marketing, and it was a very, very big trade association, really wanted to have email as a marketing mechanism. And so you had that on one side, and you had internet purists on the other saying, you know, on a very conservative, you shouldn't be using the internet for anything that's not at a higher calling or purpose. And so there was a trade-off, and that was, you know, bringing the masses to the internet. I think it was a trade-off that was made, and it was a cultural shift that happened. So it's hard to say. All right. My. That's okay.
Please stand by. There are technical difficulties.
So one of the things that I had planned to do, and I wasn't sure I was going to have time, I had like 60 slides, so if it feels like I'm rushing, that's because I wanted to make sure I gave due course to the later part of the presentation. But one of the things that I wanted to talk about, and I'll do kind of off the cuff, is what about now with a botnet, and how could that be, you know, do we need a law for botnets?
I think we do, and whoever deploys the botnet is the person who's responsible. Whether they automate or manually do the spam, it's automated, it's the same thing.
But the question
Do you
then
agree or you
becomes-
disagree? You're big red.
Very strong feelings on this.
Okay.
There should be liability for garbage manufacturers that make hard-coded credentials in their systems. They're
Agreed.
used by the botnet. It is not just the botnet herder's fault. Sure, primary blame. But if you bake crappy credentials in your stuff, you can't do it unless you reflash it or get into device issues. You have liability.
So then the question becomes, current law status. One of the things I wanted to do, so I had an example about a botnet. So under CFAA, it has to do with authorized or exceeding authorized access of a computer. And so then the question becomes, who has breached that authorization? Is it the master? Is it the bots? And then, or is it the network? And so there's all of these different pieces where you can look at legal liability. And then from a trespass to chattel standpoint, is the bot interference? And so the question I was thinking about as we started to look at it is, great, yeah, I think there's a lot of things that are wrong, but how do we enforce it? What are the legal mechanisms that allow you to sue in court, go to the Secret Service or the Department of Treasury and have them investigate, or the FBI? It's, you have to have the enforcement piece of, okay, so you did this thing that is a violation of law, and then what happens? You know, is it, you know, do we lock everybody up, or do we charge them a fine? Do we go after the manufacturers?
Well, and is it, does CFAA only say computers? Or is it now that we have Internet of Things, is it, you know, the light, the lamp, or the TV, or the whatever?
And it's only, and that's, yeah, it says computers, because it was written in sit, so yes. So the question is whether it would counter.
See, not to say you're wrong, but I question, first of all, if anybody's leveraging those, they need liability. But the question that you're suggesting is by putting a computer out there with a hard-coded password a moral hazard? You know, where it's like, here, I'm giving you, you know, like the window is open, go ahead, reach in and grab the jewels. You know, and that's a question. You may be absolutely right, you may not, and I don't know, and I'm not a lawyer. I have letters after my name, but JD aren't them, you know, but, you know, the question is it considered a moral hazard because it's something that's so easily exploited? And I still think the people who are doing the exploiting are the primary prosecutables.
So the challenge now is what do we do? If we go after the manufacturers, under what theory? So you could do a product liability theory, like, and there's a whole bunch of cases out of the 1920s when auto manufacturers started to be mass-produce automobiles, and there were questions about safety and what have you. So there's this idea we could say, manufacturers under product liability, you should have known, you knew or should have known that this product would have resulted in this kind of harm. But because the harm is not particular to one, it's just the harm and the risk is distributed across this wide subscribership, so that it's not just that you had an auto accident with one person. We have these accidents that are 10,000, 100,000 people, you know, and it's virtual, and it's a very hard thing to link the virtual and the real even now. It's much easier now, but it's still hard. So, anyway, what I will tell you is that DOJ has issued some new guidance about 3 years ago to make it easier to prosecute botnets, because the way the law was written before, you had to file subpoenas in the state for each bot. So you had to go, and now you can sort of file them centrally to request information. So you don't file in all 50 states. But it's still, I think that there's a need for more. It's just a question of what kind of law do we do? How do we get to the master? Let's say the master's overseas. Can we extradite? Do we have an agreement with that country to bring that person in? There was a case where, there was a case of a guy who was Italian who had issued a botnet attack. Maybe under Italian law, they can bring that person to the US for a trial. But in China, probably not. All right, so this is going to be, so the law is slow to change.